Hi, everyone. Welcome back to another episode of Lawyers Gone Ethical. We're going to do things a little different this time, and I'm doing a video podcast, which I don't normally do. You may be listening to this on your normal podcast app, in which case you can't even tell I'm recording the video. But this time I want to do it this way because I know some of you will find this through other means than the podcast, and you might find it through video or on social media. And I want to get this information out. So that's why I'm going to try and do it this way. Now, today's topic is State Bar of California, October 2020 bar exam, Chapter 6 violation notices. And I'm putting this information out because I want the apparently thousands of people who've received these notices to know some things, including that you are not alone. There are so many of you who got these notices. And there are many, many of us who want to help. The problem is that helping you all one-on-one has proven impossible. Now, it's not like I can't do math. I did know at the beginning of starting to try and help Chapter 6 recipients that there were more of them than me and that there was no way I could help everyone. But I honestly did not expect my phone and email to blow up the way that they did. And so, unfortunately, I'm not taking any more of these cases, and I know that a lot of my fellow lawyers are in the same boat. So I don't want those of you dealing with these notices alone to feel like you can't find relevant information. Now, we'll do the standard, lawyerly thing to give you a disclaimer, and this is actually really important. I can't give individual legal advice to all of you that I haven't talked to. I've had consultations with many, many Chapter 6 recipients. I have heard a lot of stories, and I understand what is going on with many of you, but I can't give specific legal advice without hearing the details of your case. And to that end, what I want to do in this episode is share with you what I have learned and how I am approaching responding to Chapter 6 notices. And then you can take this information and do with it as you please in responding to your notice. Now, I guess I'll give you another caveat, not to be overly lawyerly and disclaimerful, but there's not a right answer in how to approach these responses. I have talked to other defense lawyers who are doing this too, and we don't all have the same approach. I've also talked to recipients of the notices who really feel strongly that certain things need to be in their response that I might not necessarily include. So there's not a right answer, but I feel like the best thing we can do is share information right now. So I want to jump in and focus on the Chapter 6 notices themselves, because from what I'm seeing, there are two big categories of the notices. One has to do with audio issues experienced during the exam, and the other has to do with moving out of the camera view. So let's start with the audio. Many notices say that there was no audio for either a portion of the exam or even the whole exam. What I've seen, it's mostly the whole exam. Now, here's what we're doing in our office, how I'm responding to the audio ones. First, I'm detailing what kind of computer the recipient was using on the exam. As much detail as you can give. Second, I'm confirming that the Chapter 6 recipient had done the mock exams. There were two, and you should have done them, and you should have some confirmation emails, which are helpful to include. Now, ExamSoft was updated September 24th. So with some of the recipients, the mock exams were done just or only before that. Others also did them after that. I like to point out the dates. I also like to point out that the State Bar said after the September 24th update, you did not have to test again. But if you did, or if my clients did, I like to point that out. And if you had no issues with the mock exams, I like to point that out too. We did the mock exams, no problems. Now, some of my clients did have problems. So the ones who've had problems, what I've done is said, we had a problem with the mock exam. Here was the issue, and here's how we fixed it. So a lot of exam applicants have documentation about fixing technical problems, mostly microphone related, before the exam. And if they have the documentation, emails online chat transcripts. I go back to ExamSoft now and chat with them and find out ticket numbers from before the exam. Anything I can find, I've been including. I've also been explaining that there was no obvious issue on the actual exam. So from what I've been told, if your microphone's not working, when you go to log in for the mock exam, it should tell you you cannot log in. Like you should never be able to start the mock exam if your mic is not being detected by ExamSoft. So I point that out, and I also mentioned that when you logged in for the real exam, if you'd had a problem earlier and there was no problem when you logged in on the real exam, then the natural assumption is everything is working fine. Now, another thing that I do on the audio related ones is I confirm that in the exam itself, the applicant had no way of telling if the audio was working. So there was no indicator on the screen, there was no way to monitor it, there was no alert, there was simply no indication one way or the other about audio. And then on these audio ones, I like to ask my clients to check their settings and see the settings on the computer, not in the app, on the computer, and see if you can document that ExamSoft had access to the microphone on October 5th or 6th. Now, the way you do this on a PC is going to Settings, Microphone, choose which apps have access to the mic. And if you scroll down, you should see apps that have recently accessed your mic. And so there, some of my clients, we can see ExamSoft had access on October 6th at the time the exam was ending. If, some of mine, they don't say that. We can't document it. And so I have not been describing that on the ones where we don't have the date of October 6th shown, but I have been including it when we do have that date. And then when my clients have any other evidence of the mic working, I include that. Some of it's just a personal statement. I've used this computer for Zoom and Skype and no one's ever had trouble hearing me. Other times we've had some documentation, such as going onto the online help with the manufacturer of the computer and finding out from them through diagnostics that the mic is working. So whatever information that we have, I've been including to say, I know that the mic was working. Now, I've also heard from many people, it's kind of a bizarre fact, that the mic worked before the exam, but after the exam, it's not worked at all. So I don't know what that indicates as far as ExamSoft and messing with your computer, but at this time, I don't know why that has happened. And, I think every applicant has to decide whether that's something they want to discuss or not. Now, another thing I've been doing on these is sort of turning back to the bar on a couple issues. One is that on December 4th, there was a meeting of the Committee of Bar Examiners in which they talked quite a bit about the exam. And at that meeting, the Director of Admissions, whose name is Amy Nunez, said, and this is a quote, "If people were successful on the mock exam, the success rate for the actual exam should be reflected. So if you could successfully take the mock exam, you should not experience any problems at the exam." Now, I quote that because if applicants had no issue with the audio or fixed a known issue, if they did have one, on the mock exams, then you would have had no reason to know at the time that you were taking the exam that your audio was not being picked up. Now, the State Bar has also publicly at that meeting sort of touted how there were very few technical problems during the actual exam, and that they had means set up to communicate with them if there were problems. Well, I like to point out in these audio responses that you would have had no reason to know the audio wasn't working. So despite the supposed availability of resources, you would have no reason to contact the bar. So that's been my basic approach on the audio ones. Now, the other big category has to do with the webcam and coming out of view of the webcam. So here's how I've been handling those. If the applicant knows what's happening, like what happened at the exam, and goes, oh yeah, I know exactly what happened, then I've been explaining that as best we can. I know it was 2.5 months between the exam and the notices, But some applicants had things that happened that they're very clear about that happened. Oh yes, I remember, such and such a thing happened. And if you can give that kind of clarity, fantastic. I think it's great. I think those responses read really well. There are all kinds of things. I'm nearsighted, and I know I leaned in too close, and I'm sure my eyes weren't visible. I sneezed, and moved out of the view. I stretched. I had a pain. I know I moved. That sort of thing. And if you have that, I think an explanation that includes it is useful. But now a lot of applicants I've spoken to say, I have absolutely no idea. I just don't know. It's 2.5 months ago. I know I was trying to stay in view of the camera, so I have no idea what they're talking about. And in those situations, I pretty much say that in the responses. I don't think it's useful to speculate and say, I have no idea what you're talking about. Maybe I sneezed, maybe I stretched. And if you don't have a specific explanation, I've been leaving out the speculation for the most part. For all of these, I've been requesting the video. Now, I know that's another issue that's been talked a lot about on social media. I don't believe we're getting the video, but I'm requesting it in every single one. Now, for exam applicants who are comfortable with it, I've also been including if they feel they are sure they did not move out of the view of the camera. I've also included a description of the fact that you cannot view your video on an ongoing basis during the exam and still see the exam itself. I think it's important to point out that once you start the exam and you've done facial recognition and you've confirmed that you're within the window to be seen, now you're focused on the exam. And my understanding is that the camera view retracts into the top of the screen so you can see the actual test. Can't expect you to be taking the test with a bunch of real estate taken up with this camera view. Now, I'm not clear on whether you even could do that in the software or if once you click to start typing your answer, that view disappears. But either way, it's not feasible to be viewing your video the whole time you're taking the exam. Now, there's a few special situations that I've addressed in some of the responses. One is that some students or applicants who had ADA accommodations for the exam are being flagged. And if you had accommodations, I've been mentioning that. So for instance, some applicants got accommodations because of physical pains that required them to be able to get up and move and stretch. Also, applicants with ADHD, a lot of them have trouble sitting still too long. And so if they got bar accommodations under the ADA, then it seems to me that you shouldn't be getting flagged for utilizing those accommodations. So for those applicants, I've been making a point of discussing that. Also, facial recognition. This is a touchy issue, and there's certainly some racial overtones to it. Apparently, ExamSoft software has had some issues in the past where darker skinned people are not being picked up in the facial recognition. Now, this is obviously very personal as to each applicant if it's something they want to raise. What I've done is I have only raised it where the applicant has had an issue earlier in the process, like during the mock exams or signing in to the actual exam and had some facial recognition issues. But I can tell you that if you're darker than me, which doesn't take much, that is something that you may want to look into or consider in your own case. And then some of the notices are very specific. And in those, there's an easier, you kind of have an easier time of responding. So for example, some talk about, scratching their nose too much or making other suspicious hand motions during the exam. And so on those, if there's something specific, I've been addressing that as well. Now, finally, there's a couple of things that I've been including on all of the responses in some form. One is a bit of background on the applicant. Such things that might be relevant and useful include being licensed in another jurisdiction and being discipline-free for a period of time, working in a firm, law being a second career, particularly if the first career is a licensed profession where your moral character is an issue. If you're a top student in law school, I've been mentioning that. whether my clients are first-time takers or repeat takers with scores that would have passed before. It's kind of trying to paint a picture like this isn't someone who would be really having a need to be cheating if it fits whatever profile the bar thinks cheaters fit. I can tell you from the people that I've talked to, I'm not seeing any kind of pattern of real concerns. Also, familiarity with online exams. I've mentioned on some. I know some law schools were doing more and more exams online. Others, if you had ADA accommodations, for example, you may have taken the bar under the same conditions you took all of your exams in law school. I think that bears mentioning. I'm also going into the conditions under which my clients took the exam. So alone in an apartment, alone in a bedroom, cleared out the room. Point being, I followed all of the state bar's protocols. That's been the big thing I've been trying to point out. In every single one of these, I'm requesting the video. I think that the state bar needs to be providing that. And some of its early information to the bar examinees said, if you get a Chapter 6 notice, you will get the video. And they have changed the rules. And now that we have notices in our hands, they're telling us no video. They're also telling us you'll never get the video if the issue is moving out of view of the webcam, which is highly problematic. So I think we all need to be requesting the video. I also note in the notices or in the responses to the notices, if the notice is undated and unsigned, which many I have seen are, and if it was sent out in a PDF, you could still edit, because I just think these are things worth pointing out in every response. Now, to be clear, whatever any of the applicants say in response to these notices should be 100% true, as verifiable as possible, and very much spoken from the heart. These should be very forthright responses. Now, there's a couple things that are unusual here in terms of the process that I want to explain how I've been handling it. The notices are strange in that notices sent to lawyers, you're all JDs, you're lawyers, whether you're admitted to practice yet or not. They're strange in writing to lawyers that they say that both the response must be postmarked or it must be received by the Los Angeles office of the State Bar within 10 days, which is inconsistent. Those are two different things. Online, the State Bar has said you can actually upload your response through the applicant portal, which the notice on its face does not say. So I can tell you that the method that I've been taking, partly because counsel can't upload through your portal, is I have been emailing to admissions@calbar.ca.gov, and I've been FedExing, and every applicant's response I've been FedExing separately to have a separate tracking number. And I suggest that we send in our responses every which way we can to ensure they are received. We're not accused of not sending it in, and whatever method gets there first, you should get in the queue to be reviewed. I did get a response from admissions with the first response I submitted that said that they're being reviewed in the order received. Now, under the admissions rules, the bar has 30 days to get back to us in response to our responses. And the response is supposed to state the sanction, if any, they intend to impose. Now, you may notice that with the timing, that 30 days goes beyond the January 9th release date for the scores. Now, at this time, I'm expecting the bar is not releasing scores of anyone with a pending Chapter 6 notice. It's an unusual time for us. We don't really have guidance on how this is supposed to work, because typically you get a Chapter 6 notice at the in-person exam. So you're sitting in the convention hall, you do something the proctor thinks is suspicious, you get a Chapter 6 notice, and you resolve it while your exam's being scored. We're not usually dealing with these in a couple of weeks before our scores come out. But my understanding is that they won't be releasing the scores, and that you cannot register for the February exam until this is resolved. So you should be getting that response from the bar with the proposed sanction, and then you can decide whether to appeal that or not. Now, under the matrix the bar put out on December 18th, it looks like some of these violations, including moving out of the webcam view, the bar has determined are not appealable. So they're telling us we're not entitled to an administrative hearing. You just get a 0 on the exam for moving out of view of the webcam. I should clarify, their matrix says you get a 0 on the session of the exam where it happened. The problem is many of these notices about moving out of view of the webcam say various sessions at various times. So they seem to apply to the entire exam. At this time, we just don't know how that's going to shake out. The best thing that we can do right now is make sure we get our responses in, and then we will see what happens next. Now, if you are finding this process as ridiculous as I am, please consider contacting the State Bar and the Chief Justice of the California Supreme Court, as well as signing a petition that I will be posting, at least in my Twitter feed, anywhere else that I can think to post it. I do believe that public attention needs to be on these issues. And please encourage others within the bar to do the same. I feel that any member of the bar in particular has a good voice to raise, and also members of the public and members of other state bars should all be speaking up. Professors, deans, anyone who is willing to take a stand and say the way this process is going does not make any sense. I know I'd appreciate their voice, and I'm sure that anyone with a Chapter 6 notice right now would as well. So thanks for joining me on my video episode of Lawyers Gone Ethical. We'll see you next time.